Good morning, everyone. Welcome to House Judiciary. Just a few preliminaries before we get rolling. This committee, we treat each other with respect. We maintain decorum in this room and never been a problem. And that's the way we keep it in this committee, all right? And so I just encourage everyone to keep your dialogue through the chair rather than directed towards any one individual. It's Mr. Chairman, and then you can tell us what you need to say to the committee, okay? We've got 3 bills this morning. Some are rather lengthy and complex. And as I remind everyone, time is not our friend in the budget session. We have 2 hours today to get through these 3 bills. We have to be on the floor by 10 o'clock. So let's please keep our testimony tight and specific to these bills and the language within the bills. All right. Call the roll.
Representative Brady,
Here.
Representative Breton. Here. Representative Chestick,
Here.
Representative Filer,
Excused.
Representative Kelly,
Excused.
Representative Lean,
Here.
Representative Singh,
Here.
Representative Webb,
Here.
Chairman Washut.
Here.
You have a quorum.
Thank you. So we have some members who are going to have to dash out of the room to present bills in other committees. That's just the nature of things. No disrespect intended to anyone who's bringing a bill today when members are coming and going as we proceed, but that's just the nature of how things proceed. So Representative Ottman, we'll start with House Bill 103. I ask you to make sure your green light's on, speak into the microphone so everyone in the room and on Zoom can hear your testimony. Welcome.
Oh, I just need to get a pen. Thank you, Mr. Chairman and committee. I appreciate you allowing me to present to you today House Bill 103, Wyoming First Amendment Protection Act. First off, to introduce this, I have run this bill in the past and it had solid support. This bill is better and cinched up and is very, very smooth in its reading, its introduction, and the plan and purpose for what it does. So first off, a SLAPP suit, a strategic lawsuit against public participation, is a meritless lawsuit filed to silence a critic. The plaintiff doesn't expect to win on its merits. The goal is to impose enough legal cost and stress that the target stops speaking. A rancher who testifies against a proposed industrial operation, a small newspaper that covers local government, a citizen who speaks out at a public meeting, all are vulnerable to SLAPPs under current Wyoming law, which provides no specific mechanism to dispose of these suits early. 34 states and the District of Columbia have enacted anti-SLAPP protections. Wyoming has none. This bill will close that gap. The bill, HB 103, creates a substantive immunity from suit for anyone whose conduct falls within constitutionally protected activity, speech, petition, assembly, and religious exercise. The immunity attaches to privileged activities defined to cover statements in government proceedings, statements in public forums on matters of public interest, and conduct seeking to influence governmental action. The key mechanisms are immunity from suit, not just a defense. Section 1-44-103A on page 3 of the bill provides immunity from the burdens of litigation itself. This is modeled on qualified immunity for public officials. The right is to avoid suit, not merely to avoid judgment. A defendant can raise immunity in any dispositive or pretrial motion. Interlocutory appeal. It's not, okay. If a court denies immunity, section 1-44-103D allows an immediate appeal. Without this right, the immunity would be meaningless. The defendant would endure the full cost of litigation before any appellate review. Mandatory fee shifting is another mechanism. Section 1-44-104 on page 7 of the bill requires the court to award reasonable attorney fees, costs, and expenses to any person who successfully asserts immunity. This compensates the defendant and deters filing slaps in the first place. Slapback cause of action is another mechanism in the bill. Section 1-44-106 on page 9 allows slap targets to sue the filer for compensatory damages, statutory damages between $5,000 and $100,000, and attorney fees. If the filer withdraws after an immunity motion is filed, a presumption arises that the suit was in fact a slap. There's safeguards against abuse in this bill. This bill is not a blank check for defamation. It contains 3 principal safeguards. 1, exceptions for unprotected speech. Section 1-44-103E on page 5 carves out knowingly false and defamatory statements. Statements made in reckless disregard of the truth, true threats, incitement to imminent lawless action, obscenity, and any other established category of unprotected expression. Legitimate defamation claims survive. The second one is government exclusion. Section 1-44-103J on page 7 bars governmental entities and officials acting in their official capacity from claiming immunity. The bill protects citizens against government adjacent power, not government itself. Frivolous assertion penalty in section 1-44-105 on page 8 authorizes the court to award fees against a party who raises immunity frivolously or in bad faith. Next, federal court applicability. Section 1-44-107C on page 10 declares this immunity substantive law in the state of Wyoming. This matters because the 10th Circuit has held that state anti-SLAPP statutes may not apply in federal court if they are merely procedural. By designating the immunity as substantive and making procedural provisions severable, the bill is designed to apply in federal diversity cases under the Erie Doctrine. Effective date and applicability. The bill takes effect July 1st, 2026. It applies to all causes of action accruing on or after that date. It may also apply to pending actions where there is no dispositive motion has been ruled on, provided the court determines the application would not cause manifest injustice. In closing, Wyoming values plain speech and civic participation. This bill gives those values enforceable legal protection. I ask for a favorable recommendation to the full House.
Thank
Okay.
you, Representative. Committee questions for Representative Altman? Representative Justic.
Thank you, Mr. Chairman, Representative Altman. Thank you for this bill. We've talked about this bill in prior sessions, and let me start by saying I am fully in support of the concept of the bill that SLAPP suits are terrible things that need to be reined in. I do think that Wyoming needs to have, like most states do, we need a SLAPP bill. I'm not yet sure that this bill does it, and I have some really technical legal questions that I could either ask you, or do you have a lawyer to help you out with this? Provide testimony if necessary?
Can I phone a friend?
That's what I'm asking.
Yeah,
Do you have a friend to phone? Okay,
Yes, I do. Thank you.
okay, I'll ask my questions of your
Okay.
attorney at some point. I do have one policy question that I would like to
Yes.
ask you. And that is, I'm familiar with SLAPP statutes in other jurisdictions. And all the examples you gave are good examples of where SLAPP lawsuits are bad things. And the rancher, all the other people that you named in those examples do need some relief. And I agree we need to give them relief. None of those involved any claim of religious freedom. But the bill does include, in a number of places, religious claims of religious freedom as something that would be covered if there's a lawsuit against somebody's religious freedom, that person would then have a right to file a lawsuit. I'm not aware of any situations where religious freedom has been the subject of a SLAPP suit. Can you help me out with why are we going? And then the other statutes and I've seen anywhere else include religious liberty as a protected category. Why are we including that here?
Representative Ottman.
Mr. Chairman, Representative Chestick, what this bill covers is First Amendment Protection Act, and that is included in our First Amendment rights. So that's why that would be there.
Follow up? Okay. Committee, any further questions for Representative Ottman? Representative Ottman, I have one. When we have broad bills like this, that they impact a wide array of things, I'm always cautious about a situation where this language might capture litigation that's not a SLAPP lawsuit. And so is it always abundantly clear at the outset that a lawsuit is a SLAPP lawsuit as opposed to having some merit?
Mr. Chairman, I will attempt to explain that to you, but again, Mr. Crossman probably could do a better job with your judiciary and legal expertise. But what I will say is what this is that if a person finds themselves being sued, what this will enable them to do is to go before a judge, and that judge would determine whether or not there was merit to that case. So it really doesn't cover specific things. They would just say, and another reason is to help the court docket. And any case is still able to be, even if it is found the case does have merit, it can go on. If it doesn't have merit, that is still a right of the person that bringing that suit against another person to continue. But that's where the penalties and the other responsibilities of continuing enter. So do you need more?
Yeah, we may get into more. The other comment I'd just like to make right up front is every time this committee, in the many years I've been on this committee, has wrestled with questions of immunity, some of the more difficult questions we face, right? Where do you get that line? Where's the right spot to put that level of immunity? Because immunity is a powerful tool in the law. And so we sometimes will struggle on this committee trying to figure out exactly how far to go with immunity. So keep that in mind as we wrestle with this bill today.
Okay, thank you.
Further questions for Representative Ottman? Representative Webb? Yeah.
Thank you, Mr. Chairman. And mine is really simple. Did I hear that 38 states have some form of this law? Was it 38?
34
Representative Ottman.
states.
Representative Ottman?
Mr. Chairman, thank you.
39.
34 states in the District of Columbia.
Thank you.
Okay. Other witnesses on your bill? Morning, sir. Introduce yourself on the microphone. Make sure your green light's on. Tell us who you are, who you represent, and if you have some introductory statements, I know there are several questions for you.
My name is Colin Crossman. I'm here in my personal capacity, just as a citizen of Wyoming. I'll forego an introductory statement and just get straight to the questions.
And your last name again is?
Crossman.
Costa. All right, Representative Chestick.
Thank you, Mr. Chairman, and thank you for being here. I have a number of questions for you. You are a lawyer,
Yes, sir.
So my first question kind of relates to the question I asked Representative Ottman, and that is this bill as written, it's called the Wyoming First Amendment Protection Act. And other than the fact that the Establishment Clause and the Free Exercise Clause are in the First Amendment, I don't understand why we are including religious freedom in this bill. Maybe you can help me explain that. The reason I wonder about that is because the kinds of lawsuits that are considered SLAPP lawsuits are generally big companies or big, powerful entities that are trying to prevent smaller entities from protesting or filing, asserting their own opinions in a public way, and they're trying to shut down dissent. And I don't see how either the religion clauses fall into that category. The Free Exercise Clause is basically not a public participation at all. Free exercise of religion is a personal, private thing.
Mm-hmm.
I have the personal right to exercise my religious beliefs without interference, and they're not trying to harm, and they're not. No public entity, no large entity is going to be able to sue them to say you can't believe that. That's clearly not going to work, and that's not the kind of lawsuit that SLAPP deals with. The Establishment Clause is basically saying the government shall not impose religious beliefs. And that's, again, not what the SLAPP lawsuits are covering. So I'm really confused as to why we have to get religion into this bill, because it doesn't fit the category of a SLAPP lawsuit.
Mr. Cossman.
Mr. Chairman, thank you, Representative Chestick. Well, first of all, yes, you are correct. The prototypical SLAPP lawsuit is one dealing with free speech and free expression. There are areas of the other First Amendment protections that could be cognized under that as well, although I agree with you that it would be more difficult to get there. Specifically under 44-103, it discusses this as being with respect to written and oral communication. So yes, it is designed primarily with free expression in mind, but there are potentially, when you're talking about written and oral communication, I don't see the assembly component being strongly implicated there. But one could see how perhaps the free expression of religion could be covered in that, although it would also be covered under free expression as well. So these things can work together. We just felt it necessary to just be more expansive in it to cover any potential area. And of course, the judge in analyzing the immunity is going to see whether or not it applies at that moment. The immunity application is up to the judge to apply it.
Representative Chestick, follow-up.
Thank you. Another question, and you mentioned 144-103, and I have my question relates to that, the idea of immunity. And I'm wondering, again, I'm not an expert on SLAPP. I did do some research. You're right, there's a lot of states that have these bills, and I looked at several of them. I couldn't read them all because I don't have time, but every one that I looked at, none of them use the word immunity. The concept of immunity is not in any of the SLAPP statutes that I saw. Instead, they use a procedural device called a motion to dismiss, or a special motion to dismiss. That's the language that's used in most of these SLAPP statutes. And I'm wondering why we chose immunity, because when I think of immunity, I'm thinking of somebody because of their special character, their special status. They have certain rights. They are immune from suit. Police officers have qualified immunity because they're police officers. Local governments have immunity because they are the sovereign. There's all kinds, so it's a status of the defendant that entitles them to be immune. But that's not what's going on here. The immunity status is conferred upon these defendants upon the motion, as soon as they get sued. That gives them the status of being immune. So with the person filing a lawsuit, when they file a lawsuit, they create an immunity. And that is a weird concept to me. So I'm wondering, why did we go with the concept of immunity rather than the special motion to dismiss, which every other state does?
Mr. Cosman.
Thank you, Mr. Chairman, Representative Chestick. The reason why immunity is being used in this case rather than a procedural mechanism such as a special motion to dismiss or an early motion to dismiss is for the Erie fix. Under Erie, the federal courts don't have to apply state procedural law. So if we have a special motion to dismiss, the federal courts, if you're in a diversity case, the federal courts can just flat out ignore it. And by creating the immunity, which is a substantive right, the federal courts under Erie can't ignore it. So that is the kernel of the way that we believe that this will be applicable for Wyoming citizens in federal court. And because of the nature of our state being, having such a small population, if there are these suits, they're likely going to be coming in from outside, and hence be in federal court in diversity. Therefore, we felt that in order to fixing that was one of the most important components of this. And yes, you're correct. Other states haven't done this. There was a bloom of these anti-SLAPP laws several years ago, and they all followed a similar model, which was the special motion to dismiss. And then later it came out that the federal courts were going to deprecate that. Therefore, now we have the ability to say, okay, these states have done this. It has this effect. Let's do this because this gets around that. And throughout here, the immunity is cabined and somewhat protected in the sense that we have the right of the court to sanction the person for a false claim of immunity or a frivolous or a fraudulent claim of immunity. And in addition, when you look at a First Amendment case, with respect to speech, I'll just make an example here. If you have person A calls person B a jerk and person B sues them for defamation, obviously it's going to be a little more colorful than that, but that's an opinion. That's an opinion. And so the immunity can apply immediately. There's no need for discovery. There's no need for all of these other litigation techniques for the judge to say, that was an opinion, we're just get out. In a special motion to dismiss, we could use that, but then you don't have the federal court protection. Right now, you have a situation where you don't necessarily have a judge that will do that. Now, some will, but not all of them. That is obviously a very constructed example, but often you can determine early on whether the speech itself has the character necessary to grant immunity or not. And that's where why this is there at the beginning.
Representative Chestick.
Thank you. So the Erie problem is something I hadn't thought about. I haven't done the research on that. Do you have examples of cases in which federal courts have chosen not to enforce the state's anti-SLAPP statute?
Mr. Cosman.
Thank you, Mr. Chairman. I do. I don't have them readily available. I don't want to take the time. I can get them to you after the fact, or maybe in a couple minutes after some other testimony, if you'd like.
So, Mr. Cosman, I'm just trying to follow this. Somehow a state granting immunity and a state proceeding carries over into federal court? I'm trying to follow this logic here.
Okay, Mr. Chairman. So if you have two Wyoming citizens suing each other, they're likely going to be doing it in state court because they're all here. If you have a citizen of a different state suing a citizen in Wyoming, they may choose not to use state court for various reasons. And if they do, they would be in federal court. But it's fundamentally a state court claim. So the federal court would be using state law to apply. However, the procedural aspects, this federal court, they have their own procedure. They use that. They don't use state procedure. So they have to use only state substantive law. Hence why designing this right as a substantive right preserves it in the federal court.
Thank you. Representative Jesse?
Thank you. That's an interesting explanation. I see that problem, but again, I'm not sure that you need to get into immunity to do that. I think having the recitation in the statute that this is a substantive right is all you need, because as you indicated in the diversity case, state law is going to apply. And if the state law says that there is this special motion to dismiss, I would think that that's, and if we say in the statute that it is substantive law, that gets you there, I think, doesn't it?
Mr. Crossman?
Mr. Chairman, Representative Chestic, I don't believe so. I believe that the federal court would say, yeah, you can call it substantive law all you want, but it's a motion to dismiss, and therefore it's fundamentally procedural.
Part of Judiciary Committee, we like to hear differing attorneys have differing perspectives on the law. Very always interesting. Representative Ottman?
Thank you, Mr. Chairman. And just to add with the immunity from suit, if any action impacts or arises from privileged activities, the defendant is entitled to immunity from suit from the burdens of litigation itself, not just from ultimate liability. This tracks the Supreme Court's description of qualified immunity. Covered activities include statements in governmental proceedings, including pre-litigation demand letters, statements in public forums on public interest issues, and conduct seeking governmental involvement. The list is non-exclusive. So that's just to add to that.
I have a question on page 5, line 21, or down in that area. We're talking about, no, not 21. Where is it out here? But when we're talking about immunity under this statute for various individuals, I'm wondering if that immunity, does it stack with immunity granted elsewhere? You know, legislators, for example, have constitutional immunity for debate and so forth. And then in this bill, we grant them additional immunity. I'm just wondering, how do these apply? Does this undermine the immunity granted to these individuals elsewhere, or does this stack on top of that immunity, or does it just create a conflict and controversy?
Mr. Chairman, I don't believe that if you were an individual that had multiple types of immunity that could apply, for instance, the speech and debate component while in the House, although I know that is a federal immunity, but if that were to apply to you, I believe that would be a stronger immunity than this. So I don't think there would be a conflict. Similarly, if there was a police officer or a government official that had qualified immunity, I believe that would be a stronger immunity than this. And so if you had multiple types of immunity that applied to you, I don't think they would be in conflict. You would just choose which one was more applicable to that situation and proceed under that. So maybe stacking is not really the right way to look at it, although I guess they would all apply simultaneously, but they all end up with the same result.
Very good. All right, we're at 8:30. Are there other witnesses on this bill? Good morning. Please make sure your green light's on, then identify yourself, who you represent, and tell us what you want us to know succinctly.
Good morning, Mr. Chairman and members of the committee. My name is Kari Cochran and I live in Rock Springs, Wyoming. I'm a former member of the Sweetwater County School District No. 1 Board of Education, speaking here on my own behalf in support of House Bill 103. I'd like to share my story with you as a mom and as someone who was recently taken to court by 2 school officials because I spoke out about the district on social media. 3 years ago, I experienced what no parent should ever have to. My son, Joran, took his own life after enduring bullying, sexual harassment, and mental health struggles as a high school student. Since then, I've spoken out about the district's failures to address bullying, mental health, transparency, and accountability. 2 years ago, I stepped down from the school board because I felt I could do more to advocate for change as a parent and a community member than I could on the current board. My advocacy has involved making public comments at school board meetings, communicating by email with the board and other officials, and speaking out on social media when I believe the district or school officials have violated the law, ethical constraints, or district policies. Last summer, I was at home when I received a knock at the door and a sheriff standing there to serve me with not one, but 2 orders to appear in court over allegations of stalking the superintendent, the assistant superintendent, and another filed by the superintendent's wife, who is currently a district contractor on behalf of herself and the superintendent. Both petitions were based on my online posts and comments. If granted, these orders would have barred me from contacting those public officials in any way, including by phone, email, or social media. The assistant superintendent even asked the judge to ban me from attending public meetings she attended and the schools in which my daughter attends. This would have kept me from being an active parent in my daughter's education. I was stunned and overwhelmed. I didn't have an attorney, and I was expected to be in court in less than 2 weeks, all because I dared to speak out against the district that failed my son and is now participating in my daughter's education. Fortunately, by the time I was sued, the media learned about Joran's death in a dispute I had had with the district over his school records. Parker Jackson, an attorney with the nonprofit Goldwater Institute, reached out and connected me with another Wyoming attorney, and I was able to have legal representation at one of the hearings I was forced to attend. Thankfully, the 2 judges assigned to my cases both recognized that the stalking allegations brought against me were improper and targeted my constitutionally protected speech. One judge dismissed the first case without a hearing, and the second judge also dismissed the other petition after a brief virtual hearing. But the truth is, I should have never had to appear in court at all. The allegations were groundless and aimed at silencing my advocacy as a parent and a community member. If House Bill 103 had been law, my cases would have been resolved more quickly or might never have been filed in the first place. Protections like House Bill 103 are vital to protect and give practical effect to our constitutional rights. Parents, students, educators, and communities should be free to voice their concerns for children's safety and well-being without fear of being dragged into court. If someone abuses the legal process to punish constitutionally protected speech, the target should not face financial hardships or the stress of drawn-out litigation. I am very happy to be able to have had Goldwater offer pro bono legal representation when they were able. Their support empowered me to defeat the intimidation and punitive tactics that often arise when individuals dare to engage in free speech. But pro bono help isn't always available. Every Wyoming citizen, no matter their income or social status, should be able to exercise their constitutional rights without fear that the legal process will be used as punishment. House Bill 103 would help to make that a reality, especially as so-called lawfare has become so prevalent in our society. This isn't about revenge, it's about reform. It's about ensuring that no one weaponizes our legal system to punish dissent or silence lawful expression. The loss of my son will always be the hardest thing I've ever faced. All I ever wanted to do was ensure that no other child or parent would have to endure the same heartbreak. In my efforts to keep his memory alive, I courageously have spoken out, even as it's brought unexpected pain. I've stood up for what's right amidst the challenges facing our school district, and I was sued because of it. So today, you have a chance to ensure that the next parent or taxpayer that speaks out will have the additional meaningful tools to protect their rights. I hope that you will support House Bill 103 so that real change can happen that will help others. Thank you for listening to my story, and I stand for any questions.
First, let me say thank you. I can't imagine the loss, the pain. And I appreciate you coming before the committee this morning.
Thank you, Chairman.
Member Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today, and thank you for having the courage to speak up. My heart goes out to you.
Thank you.
My question is, are you still in litigation or have these been resolved?
Ms. Hackman.
Chairman, Representative Lean, they have both been dismissed and denied. I was requested to be in court twice for one of the suits, and one was dismissed without even attending a court process at all.
Is this your attorney next to you?
Yes.
Do you wish to testify too, sir?
Yes, good morning, Mr. Chairman, members of the committee. My name is Parker Jackson. I'm a staff attorney with the nonprofit Goldwater Institute. I live in Lyman, so I'm a Wyoming resident as well. And I'm licensed to practice law in Wyoming, Utah, and Arizona, and I appreciate the opportunity to offer some additional comments in support of the bill. Speaking both as a Wyoming resident and on behalf of the Goldwater Institute. I'll talk a little bit more about some of the legal intricacies of Ms. Cochran's cases, as well as kind of how the bill maybe would have made a difference. So I became aware of Ms. Cochran's situation due to some media coverage about an unrelated dispute. And while we were kind of talking about that, she was served with these lawsuits. And it was pretty apparent to me as soon as I saw the orders to appear that they were based solely on her protected political speech, her online expression. The petitions attached a variety of social media posts and news articles and public comments, but nothing in the nature of stalking or threats or harassment. And so we figured we needed to get involved, and we knew that Wyoming was one of these states that did not, unfortunately, have an anti-SLAPP law in place. It kind of depends on how you count. The Institute for Free Speech publishes an annual report card on anti-SLAPP laws, and by their count, we're now up to 39 states that have some form of anti-SLAPP protection. The most recent being Michigan. Just this last December, they enacted an anti-SLAPP bill, and it was passed unanimously on a bipartisan basis out of both houses of their legislature and signed by the governor. So that a positive step in the right direction. Historically, anti-SLAPP laws were largely designed to protect members of the press. It was designed to protect reporters that were, asking tough questions of government officials, so that the government officials wouldn't turn around and sue the reporters for asking tough questions. And then it's kind of grown from there. All of these anti-SLAPP laws are largely based on a model bill called the Uniform Public Expression Protection Act, or UPEPA. And getting at some of the previous questions, every state kind of varies in the scope of the coverage and the types of rights that these laws cover. This House Bill 103 would be extremely broad, which I think is a good thing. It covers the full panoply of First Amendment rights in various capacities, as well as the rights that are protected sometimes to a broader extent under the Wyoming Constitution. I think that's an important piece here as well. And on that note, I wanted to read just a short paragraph from the court's. There were two orders that were issued denying these petitions in Kari's cases. The first judge issued a very detailed written order in lieu of holding a hearing. The second judge held a hearing and then issued a very brief written order. But the first judge specifically wrote, the statements made by respondent Ms. Cochran are expressions of dissatisfaction with the petitioner, this was the assistant superintendent's activities in her role as a public official. As such, the statements fall within constitutionally protected speech. Both the First Amendment of the U.S. Constitution and Article 1, Section 20 of the Wyoming Constitution prohibit this court from enjoining future statements by the respondent, which are critical of petitioner, even if the intent of the respondent is to negatively impact petitioner's employment. The Wyoming Supreme Court and United States Supreme Court have repeatedly ruled that the constitutional guarantee of freedom of expression forbids prior restraint of protected speech. So the question is, why are we here if Ms. Cochran's cases, ultimately turned out right and they were dismissed? Well, the problem is not just the ultimate outcome of the cases. The whole point of this is she was drugged through the legal process, right? The process itself was used as a punishment and retaliation for some of her speech. And House Bill 103 really gets at that problem of using the legal process in inappropriate ways. The bill would have made a difference, I think, in three regards in Kari's cases. So first, it's probable that the petitions probably wouldn't have been filed. So one of the really important components of anti-SLAPP laws is they really just provide a deterrent against, misusing this process. In Wyoming, when somebody files a petition for a stalking order of protection, there's not even a filing fee associated with that. That's really good in the context of actual stalking, because you don't want a victim that can't file a petition. But that makes that process really susceptible to abuse when the people that brought these lawsuits against Kari, they literally had nothing to lose. they could file the petition, they could go to, spend an hour in court, and no skin off their back. It didn't cost them anything. I don't believe they were represented by an attorney. And, that just calls out for some sort of reform to kind of curb that behavior. Second, the second case that actually did go to a hearing, that probably wouldn't have happened. We probably wouldn't have had a full-blown second hearing on the second case. And that involved, legal time and, fortunately we were able to step in on a pro bono basis, which is what we do because we're donor funded, but not everybody has access to pro bono representation. We can't be everywhere all the time. And so providing that attorney fee provision really is critical because it helps people to be able to obtain an attorney if they need one in the first instance. And then, once they get into the process, those attorneys are able to quickly assert the immunity or file these motions to get rid of these cases more quickly. And then in the context of if there was a private attorney, they'd be able to recover those fees because the whole point of providing these types of procedural and legal remedies is to make the person that was targeted whole. We want to go back as close as we can to a situation where, it's as if they were never sued, right? So if they had to, incur expenses, whether it was attorney fees or costs or travel or anything as a result of being improperly sued, they should be able to recover those costs from somebody who brought these improper lawsuits.
Thank you, Mr. Jackson.
Yep. So that you got right to the end. Those
Time
were
is not our friend.
3 points that I wanted to make. I think this bill would have made a huge difference. I think the bill is very thoughtfully written, and I can tell it's been through the process once. So I'd stand for any questions.
Representative Shostak.
Thank you, Mr. Jackson. I appreciate your, Ms. Cochran's case is exactly the kind of case that this should cover. I think you're absolutely right that that was a SLAPP lawsuit, and I'm glad that you were there as a pro bono attorney to stand up for and do the right thing. I think this is the kind of case that we should be covering. I do agree with that very much. I think there's a third and a fourth thing that the anti-SLAPP part of the bill might also give her a remedy going forward from here. If this bill had been in place, the anti-SLAPP part of it could then kick in and she would have a further remedy to make herself whole. So there's another thing that my question for you is real short, and it's, I've alluded to it before. There's no religious overtone to any of this. This is all strictly speech and First Amendment. Would you agree that the SLAPP lawsuits involving religious liberty are rare, if unheard of?
Mr. Jackson.
Mr. Chairman, Representative. Two things. Yes, the first part you were referring was the slap back provision. I think different states handle that differently. Some may treat it as like a counterclaim or a countersuit within the original action. I think the point of doing it this way and separating it out is you get rid of that first frivolous lawsuit as quickly as possible. And then that minimizes the damages, right? And then if there were damages incurred, then you provide that separate slap back. I don't know that there would have been damages in this case because of our pro bono representation, but you're right that is in some cases would have been important. On the religious freedom side, the Institute, to be clear, doesn't take a position on the religious freedom portion. It is unique, I think, among anti-SLAPP statutes. Typically, so the UPEPA that I mentioned before, the model bill, it separates out speech, petition, assembly, and it adds association, which that's kind of a combination of those three things. And it also separates out the press. I don't know that the press is necessary, just because typically what the U.S. Supreme Court has said is that those rights are coextensive with free speech rights. But there's obviously overlap in all of those things, right? And there's a reason it's called the Uniform Public Expression Protection Act, the model bill. And we're trying to protect all forms of expression. And that might be religious in nature, it might not be. So that really, how you word that's a policy question for the committee. But I would just encourage you that the broader you can encompass expression, the more rights and remedies you're going to provide for Wyoming citizens.
Thank you, Mr. Jackson. Appreciate you both being here this morning.
Thank you.
Others in the room, do we have anybody on Zoom? Okay, very good. Anybody else in the room on House Bill 103? Good morning. Make sure your green lights are on, and then introduce yourselves, who you represent, and tell us what you want us to hear. If you keep in mind that we are up against the clock.
Thank you, Mr. Chairman. We'll be brief. Jonathan Downing and Steve Kiggins appearing on behalf of Wyoming Press Association, rising in support of the proposed legislation. Briefly, before turning it over to Steve, Press Association and our Main Street newspaper members have always been supportive of this type of legislation as far as the protections in place for a free press. With that respect, we do believe there is a bill needed. If it moves through the process, or whether that's interim or moving forward through the committee into the floor, we'd be open to working with sponsors or opponents on amendments to help keep it moving forward.
Thank you.
Mr. Chairman, members of the committee, good morning. My name is Steve Kiggins, and again, I'm the Executive Director for the Wyoming Press Association. The WPA, on behalf of its 39 member newspapers of record across Wyoming, fully supports any legislative actions that strengthen open government, safeguard our First Amendment right for free speech, and protect our local journalists' ability to report without restriction or retaliation. As we've heard today, this morning, Wyoming is one of just a handful of states without any anti-SLAPP statute or protection to prevent abuse of the legal system against those who were sued for exercising their First Amendment rights. HB 103 would stop frivolous lawsuits and be a deterrent for people bringing weaker claims. I would also encourage public debate. Wyoming citizens rely on our local journalists and trust them to provide news and information on government, education, public safety, and the issues that shape their communities. A free and independent press then is essential and protects not only our members, but the public's right to know. Thank you very much and appreciate your support, your consideration of support for HB 103.
Thank you. Questions? Appreciate you both being here this morning. Others in the room speaking on House Bill 103. I knew it was just a matter of time before you would be in
You
committee.
knew it. Good morning, Mr. Chairman. Beth Lance from the Wyoming Trial Lawyers Association this morning. First, I just want to say our membership is fully in support of the concept of this bill. We are not against Wyoming having some form of anti-SLAPP legislation. So I want to be clear about that. Our members fully support First Amendment protections. We do have concerns with this version of the bill. However, it is extremely overly broad, and it goes pretty far into creating, the only way I can describe it is almost a separate legal universe for this type of lawsuit. It's not working directly within our already long established rules of civil procedure, rules of evidence, the rules we have governing our motions, the rules we have governing judicial discretion, the rules we have governing attorney fees and costs. Those rules all already exist. And this seems to be trying to create new types of rules just for this legislation. And that's concerning to the attorneys because I think it's concerning how is that going to be applied. Specifically too, if you look at a few pages of this bill, there's just a couple things I wanted to point out. On page 6, section F, it essentially requires the parties to waive their right to a jury trial. In this bill, we certainly would not be in support of any requirements to waive our constitutional rights regarding jury trials. Additionally, if you go on to section G, it has a very broad statement that the immunity from suit under this section applies regardless of any cause of action claim or counterclaim asserted under the laws of this state. So that's extremely broad. And when you go all the way to page 15 under section 3, it states that this act applies to all causes of action accruing on or after the effective date of this act. And then in section C, I'm just concerned, I don't even know that I recognize this type of language or what this is seeking to do. stating that the court in its discretion determines that the application of this act would not cause manifest injustice to any party. I've never seen that in the law. I don't know what that is or what that's trying to do. So there's just a lot here that is very concerning as to how would this look in reality if this were applied, and that can cut both ways. If a bill passes that in reality doesn't apply, necessarily the way even the drafter intended, it can have unintended consequences. And that's something that we just don't want to see. We want to be sure that any anti-SLAPP legislation in Wyoming, we can fully understand how that's going to apply and be sure that it is accomplishing exactly what it is meant to accomplish. Of course, yes, many states do have anti-SLAPP legislation. A lot of it looks very different than this, though. This is fairly unique in the way that it is drafted. Specifically looking at Texas, their anti-SLAPP legislation has 13 enumerated exceptions to ensure that it's very clear what that legislation is covering. And here, these two broad exceptions, I think, are quite unclear. And so I just continue to be concerned with the wording and the way this is drafted, whether we're reaching the proper intent. And I would stand for any questions.
Representative Chester.
Thank you, Mr. Chairman. Thank you for being here, Ms. Lance. You probably can anticipate the questions I have from the earlier questions I had. I agree with you that anti-SLAPP legislation is necessary, and we just had an example of a case where it would have done some good. But I also am concerned about the breadth of this. Have you ever seen another state's anti-SLAPP statute that protects religious liberty? And what would a SLAPP lawsuit look like in the context of an exercise of religious liberty? Do you have any ideas what that means?
Ms. Lance.
Mr. Chairman, Representative Chestick, I don't. I am not familiar with SLAPP legislation regarding religious freedom specifically. I think the testimony we heard from the attorney earlier who had represented the woman in her lawsuit was clear that as far as the religious, there may be an argument that, when we're looking at the language of that uniform bill at the federal level, when it talks about association and things of that nature, that probably that there could be an argument that includes religion. So I generally agreed with his testimony regarding that. I don't have anything additional to offer on that question.
Representative Chester.
Thank you, Mr. Chairman. One final question. I think you were in the room when Mr. Crossman was testifying about the immunity issue and the need to have the substantive law piece of this in order to avoid the Erie problem. Do you agree with that? And do you think that the usual, every other SLAPP statute I've ever seen uses the special motion to dismiss? Do you think the special motion to dismiss would be sufficient?
Ms. Lance.
Mr. Chairman, Representative Chestick, again, this is my concern. I think that this concept is still a concept. I don't know that we've seen this idea of immunity in practice. And so that is my concern. Then do we know what the effect will be if that kind of legislation were to pass, where if we were following the well-established anti-SLAPP legislation that does exist in many other states, it's much more predictable for us to understand how the courts are going to take that and interpret that. And I think that's the overall concern, is how would this work, and will it actually be beneficial, or will it have unintended consequences?
Thank you. Do you wish to testify, sir?
I'll be very brief. My name is James Halverson with Americans for Prosperity right here in Wyoming. I'm just going to give a simple me too. We think this is a good bill. We heard some powerful testimony earlier. And my question there is, well, who else did that prevent from coming forward and maybe speaking out? If we can't afford, or if we're too intimidated to exercise our rights, then we don't have them. So we encourage you to move this bill forward, and I thank you for your time.
Thank you very much. All right, we're coming up on 9 o'clock, halfway through our morning session on our first bill of the day. I don't mean to rush, but it's a reality for us.
No, I
So Welcome
understand
this
that.
morning and tell us what we need to hear.
Thank you, Chairman, and members of the committee. My name is Laura Gratt. I represent the Wyoming Association of Broadcasters. We stand with the Press Association in their testimony. As you probably know, they're up here covering the legislature. You probably already had a microphone in your face or a camera, but they should be able to report on public issues without the burden of being hit with a lawsuit. So I'm going to keep it very brief and just ask for your support.
That's very brief. Thank you very much.
Thank you.
Any questions? All right. Thank you for being here.
Thank you.
Anyone else in the room wishing to speak on 103? Seeing none, anybody on Zoom? All right, we're going to close public testimony. Committee, what's your pleasure? Moved by Singh, second by Webb. Discussion on the bill or amendments? Start with amendments. Representative Chesty.
Thank you, Mr. Chairman. Before I propose amendments, and I do have several I would propose, I want to kind of test the waters here with the rest of the committee members. I think this is a good bill. It's a good concept. It needs work. I think it needs significant work. Some of the questions I was asking, some of the concerns raised by Ms. Lance, I think all need significant work. We can either try and amend the bill here on the floor in the committee right now or on the floor, take a lot of time, or my preference would be to table the motion, table the bill and take it up in the interim when we have more time to deal with it and do it right, and then move it forward for next session. So I move to table the bill and encourage this to be appointed as an interim topic for next summer.
Motion to table is always in order, not debatable. Call the roll on motion to table.
Does that need a second, Mr. Chairman?
I don't believe it does.
Okay.
Representative Brady, No. Representative Breton, No. Representative Cheswick,
Aye.
Representative Filer,
Excused.
Representative Kelly,
Excused.
Representative Lean,
No.
Representative Singh,
No.
Representative Webb,
No.
Chairman Washut.
No. All right, you have your answer? Mr. Representative Chesty.
Then I have some amendments. First Amendment, and this actually shows up in a number of places. But my concern is the inclusion of religious liberty, and that's on page 3, I believe. The right of religious freedom on page 3, line 1. I'm concerned about the breadth of that. I haven't seen that in any other SLAPP legislation. I'm very concerned about unintended consequences here. This is a fraught area. There's already well-established law on freedom of free exercise of religion and establishment clause, and none of those really involve public participation. The free exercise is a personal matter. It's not public participation of any sort. It's private. So I don't think this bill should cover free exercise clauses. And the establishment clause is a prohibition against the government from doing things. So again, I don't think either one of those religious freedoms, and the word religious freedom is not defined. So my motion is to, it's going to take a second to get them all it's going to be in several parts. The first, on the title of the bill, change the title of the bill from Wyoming First Amendment Protection Act to Wyoming Anti-SLAPP Protection Act. That's on page 1 in the title. Also on page 2, line 5, the short title, on line 5, change First Amendment to anti-SLAPP. So it would be the Wyoming Anti-SLAPP Protection Act. On page 3, line 1, delete the words "and the right of religious freedom." And there are a few other places in the bill, if I see if I can find them quickly, where the word religious shows up. Page 1, line 4. Yeah. There's a number of places.
Throughout the bill.
Throughout the bill, wherever religious shows up, delete the word religious to make it clear that all the other First Amendment rights, freedom of association, freedom of the press, freedom of speech, all those are still covered. But the religious part is unique and kind of overbroad, and I don't think it really fits the purpose of the bill. That's my motion.
Is there a second to the motion? I'll second it for discussion purposes. Any discussion on the motion? Representative Webb?
Is there a way that this could be divided into two? The religious portion and then possibly the anti-SLAPP as a different motion?
Representative Chester can respond.
Sure, I have no problem with that division.
We typically try not to divide them motions on the committee level. It
Yeah.
can get really time consuming and difficult. I will say that I've never in committee seen a motion to amend the title of the bill. That's a first one for me. I don't know that it's off limits, but it's a first.
Mr. Chairman,
Representative Chester.
I do believe that the amendment is consistent with the intent of the bill. I'm not changing the intent of the bill at all. I'm limiting its scope a little bit, but probably not even that much because I can't imagine how a religious claim under SLAPP would come up in the first place. So I'm just focusing the bill, but it's keeping the original intent, so I see no problem with amending the title.
All right. So the motion committee is to amend the title, both the title and the catch title, and then to strike religious freedom from wherever it might occur within the bill, including on page 1, line 4, page 3. Everybody clear on the motion? All those in favor of the motion say aye.
Aye.
Those opposed, no.
No.
Motion fails. Further amendments? Representative Chester.
Thank you, Mr. Chairman. On page 6, lines 7 through 12, I also had concerns about that, and Attorney Lance also raised that as a concern. I wasn't quite sure what the intent was, but I think it's an undue burden to coerce somebody to waive their right to a jury trial. So I would move to delete subparagraph F on page 6, lines 7 through 12.
Is there a second to delete paragraph F? I'll second that. Discussion on the motion? I know the little research I was able to do with Uncle online, I won't use what I usually call it, in my online searches on this topic, some of the SLAPP laws that were overturned on this issue of jury trials. And so that's why I support this motion. Any further discussion? All in favor of the motion to strike paragraph F on page 6, say aye. Aye. Those opposed, no.
No.
That fails. Further amendments? Representative Chester.
On page 5, lines 6 through 8, I am concerned about the word deem on the end of page 6, so that whole clause, and the court may deem the motion to dismiss as evidence that the immunity motion is meritorious. I think that puts too heavy a thumb on the scale. It's a little unclear as to how that language would work, but it looks like it's creating a conclusive presumption that as soon as the motion is dismissed, if somebody withdraws their motion, withdraws the lawsuit, they're admitting that they were wrong in the first place and they can be sued for a slapback case. And I think that's a little bit it's going to create an incentive not to dismiss the case frankly. So I think that's counterproductive, and I would recommend deleting, changing on line 6, the comma to a period and ending the sentence there.
So where's the period on line 6?
Where the comma changes to a period and you delete the rest of the paragraph, and the court may deem, et cetera, is all deleted.
Is there a second? I'll second for discussion. Discussion on the motion? No discussion? Anything further, Representative Chestick? I agree that I think it does actually work in a counterproductive fashion to discourage withdrawing the lawsuit. So that's why I'm going to support this. All in favor of
Mr. Chairman.
Representative Vice Chair?
Thank you, Mr. Chairman. Just to clarify, we're on page 5, line 6.
Line 6 to the remainder of the
To the end.
paragraph.
Okay, thank you.
Okay, all in favor, everybody clear on the motion? Do you have it? All right, all those in favor say aye. Aye. Those opposed, no.
No.
That has failed as well. Further amendments? Seeing none. Sensing an urge to vote, call the roll on 103.
This is a roll call vote on HB 103. Representative Brady.
Aye.
Representative Breton.
Aye.
Representative Chestick.
No.
Representative Filer.
Yeah, he left a vote, I believe. He's an aye vote.
Representative Kelly.
Excused?
Representative Lean.
Aye.
Representative Singh.
Aye.
Representative Webb.
Aye.
Chairman Washit.
Aye.
7 ayes, 1 no, 1 excused.
Thank you. That concludes our work on 103. Representative Ottman, you'll have it on the floor. Next for our consideration is House Bill 70.
Yeah.
Your turn to be on the other side of the table again. Representative Singh.
Thank you, Mr. Chairman, members of the committee. I'm here to present House Bill 70 today, which is the Wyoming Granite Act. Granite meaning guaranteeing rights against novel international tyranny and extortion. And I'm just going to run through the bill, folks. I know that time is of the essence, and so a lot of us may be thinking, what is this bill for? Why is it important? Well, you can find that in the legislative findings, which is section 1. And I'm going to take your attention to page 3, starting at line 1. It's that the United Kingdom's Communications Regulatory Agency, or the Office of Communications, is threatening fines of not more than $25 million, or 10% of a company's total worldwide revenue for noncompliance with their laws. And the Brazilian Supreme Court has ordered the United States platforms to censor user accounts and disclose user data to the Brazilian Supreme Court. These foreign entities are using their authority as a sovereign to impose upon American companies, and through that, American users, Wyoming users, their restrictions on free speech. And though it is a new matter, it's a serious matter. And so I think this is an opportunity for us to really take a stand and be leaders when it comes to the fight for free speech on the internet. These actions that foreign governments are taking conflict with the United States Constitution. On page 3, line 16, they conflict with the United States Constitution and the Wyoming Constitution by chilling the speech of Wyoming residents. On line 22, Wyoming has a compelling state interest in safeguarding the free exchange of ideas. And then if you go on to page 5, line 17, foreign states and international organizations have increasingly sought to criminalize constitutionally protected speech by issuing criminal foreign judgments, arrest warrants, and extradition requests that deprive persons in the United States from lawful expression that is constitutionally protected by the United States. So those are just some of the findings, and they go into detail continuing through page 8 and the beginning of page 9. You can find the purpose of this bill starting on line 19 of page 9. The purpose of this chapter is to protect the constitutional rights of Wyoming residents and business entities from the extraterritorial application of foreign censorship laws by establishing in-state forum with clear and predictable jurisdictional rules and effective remedies that are consistent with federal law. And they promote Wyoming's economy by fostering a safe harbor for digital innovation and ensuring that foreign threats do not deter investment in Wyoming business entities. As we continue, so page 10 through 11, 12, 13, and 14 to line 15 on page 14 includes definitions. And then starting on page 14, line 20, we start getting into the meat of the bill. It says that a plaintiff, it creates a cause of action, statute of limitations. A plaintiff described in Wyoming Statute 144-105A shall have a cause of action against any foreign state, international organization, or any officer, employee, or other person thereof acting within the scope of their official duties who has threatened to enforce, attempted to enforce, or enforced a foreign censorship law in a manner that would violate the First Amendment. The cause of action under subsection A of this section shall apply only to the extent permitted by federal law, including the Foreign Sovereign Immunities Act and the International Organizations Immunities Act and any applicable headquarters agreement, treaty, or executive order. And as we continue through the bill, Mr. Chairman, on page 17, line 11, we see who exactly this would affect. On line 17 of page 17, it would affect a Wyoming resident. On line 19, it would be a natural person who is physically present in the state when a foreign state attempts to enforce this kind of an action. On page 18, line 4, it's a Wyoming business entity. And page 18, line 6, any United States person whose protected expression, expressive conduct, or expressive association originates from or is hosted on servers physically located in this state. So if there's an entity that is hosting the actual physical infrastructure to create that kind of a service, a social media service, that if they host that server physically in Wyoming, that this law applies to them. And continuing on, if we go on to page 20, starting on line 20, it gives some direction to the court. And this affects the state statute 144-106. A court shall presume that a foreign censorship law violates the First Amendment of the United States Constitution, Article 1, and Article 1, Section 20 of the Wyoming Constitution, and Article 1, Section 21 of the Wyoming Constitution. So this gives that direction to our judicial system that if there is a foreign censorship law that's being attempted to be enforced, that we would assume that it is not constitutional. Continuing on, Mr. Chairman, to page 22. If you go down to line 17, this talks about the actual damages that somebody could seek. Statutory damages of $1 million per violation as adjusted for inflation under subsection C of this section, or 10% of the defendant's annual United States related revenue, whichever is greater. So that's the big punch in this bill, Mr. Chairman. And then continuing on to page 25, we talk about the non-recognition of foreign judgments and cooperation with foreign judgments and extradition requests, penalties, and cause of action. If you look at line 12 on page 25, no court of this state shall recognize, enforce, or give effect to any foreign judgment, order, subpoena, administrative action, fine, penalty, or similar measure that imposes liability or compels action based on expressive conduct or expressive association that would be protected by the First Amendment of the United States Constitution, and similarly in Wyoming Constitution. On page 26, line 7, except as required by federal law, the state, its political subdivisions, and its employees acting within the scope of their official duties shall not provide assistance or cooperation in collecting, enforcing, or giving effect to any foreign judgment as it applies to free speech in the Constitution. Any person who violates the subsection faces a $10,000 fine per violation. And then the next major part will be in page 31. starting on line 22. It just affects the statutes regarding actions against non-residents and foreign corporations. Section 4 is that the Attorney General on page 32, line 6, the Attorney General shall promulgate all rules necessary to implement this act. And Section 5 is the enactment date. And there's just a difference in the subsection A and B, which would be effective July 1st of this year. And then sections 4 and 5 of this act are effective immediately. And I do have some legal support, and we do have a person who wants to give some testimony online, but there's the bill, and I'm hoping I'm being expedient with our time, Mr. Chairman, but with that, I stand for any questions, and I will have a friend available to phone a friend, so.
Thank you, Representative. I want to applaud this. I think this is a growing concern. You know, Americans go on vacation to the UK and find themselves being arrested for something that they posted on social media from Connecticut, right? And it just seems absurd. Who would have ever guessed? On the flip side, I think for the committee to work this bill and to understand what this bill accomplishes and what it doesn't requires us to have at least a reasonable working understanding of 28 USC 1608, 22 USC 288, the Foreign Sovereign Immunities Act, the International Organization Immunities Act, and other legal treaties that you reference in your bill. And I'm just wondering, is this too big of a piece of bubble gum to try and chew during a budget session? Your comments.
Mr. Chairman, and for the record, I do love bubblegum. But look, this is an ongoing problem that it's a modern problem that we have not anticipated. And with the invention of the internet and the expression of speech on a network type of a basis, other governments are taking it upon themselves to punish American intuition and the services that allow for free speech. And when we consider, especially in those parts of the world where they don't have freedom of speech like we do, it's an exception to the rule. And of course, I appreciate caution in addressing any sort of big idea, but I believe that we ought to lead the charge. And yes, if there are things that need to be worked through, I have amendments to this bill, Mr. Chairman, and I've distributed them to the committee. But ultimately, I think we need to act expediently on this. Wyoming has already been noted as for leading the charge on this particular idea, and since we have come out with this bill, 3 other states have seen it and decided that they want to follow our lead. And so I'd like to work on the bill, make it work. And yes, it's complex, but I don't think we should be afraid of shooting for the stars.
Further questions, Representative Chesky?
Thank you, Mr. Chairman. Thank you for bringing us the bill, Mr. Vice Chairman. I share the chairman's concern that this is a huge lift. It's a very complicated bill. I'm not sure I understand all the ins and outs of the bill myself. I'm not an expert on international law, but the extraterritorial application of this is what concerns me. It seems like, I know we have a full faith and credit clause for within domestic law. So the state of Wyoming has to recognize laws from other U.S. states. That's full faith and credit. I'm not aware of a full faith and credit clause for foreign laws. Another foreign law is not applicable here, nor would our law be applicable over there. So are we trying to impose our laws on other foreign states? And that's some of the language here suggests we're trying to do that. And so we need to be very cautious about we're trying to export our law to other jurisdictions without letting them export their law to us. And whether that's going to work, I really don't know. It's a very, very complex bill. So here's my question you say we're a leader on this. Are we the first to do this? I see a reference here to a New Hampshire law, but are we really leading the charge here, or are there other states that have actually enacted bills like this?
Representative Singh.
Thank you, Mr. Chairman. So to what you just said, Representative Chestick, Wyoming is the first state to have a standalone bill dealing directly with foreign censorship. And to your other point about whether or not we would be imposing our laws on other foreign sovereigns, the situation that we find ourselves in is that they, because they do not hold the same standard of free speech, because they have it within their ethics that their government can attempt to censor people based on their political speech or things that they may deem as hateful or inappropriate, they are instead imposing fines upon us, and they're using their power to cross their borders and inflict fines and judgments upon people that live in countries outside of their own jurisdiction. And so this provides a shield, a censorship shield, so that they think twice before attempting to do something like that.
Follow up on that, Representative Singh. Our system of government gives foreign affairs preeminent policy to the national government, not to states. It becomes problematic, I think, when we try to intervene to some extent into that domain. And that's my big concern, because if I vote yes for this bill today and somebody says, well, what does that bill accomplish? Given all of the limitations of these other federal laws and acts and treaties and so forth that aren't even identified, right? Any other international treaty. I couldn't answer the question. I could not look at a constituent at the grocery store and tell them what this law will actually accomplish because of the limitations that are identified in the bill with all these other federal laws. That's why I'm thinking that an interim study at least might give us the opportunity to bring in those people who have expertise in those subject areas to tell us, with all the limitations that these federal acts put in place, your statute accomplishes this much, right? And then we have to decide, is that much worth it? Might there be another approach? If this were a joint resolution calling upon Congress or the chief executive of the nation to, intervene on behalf of the American people who are having their constitutional liberties constrained by the actions of foreign governments, that's an easier pill to swallow in a budget session. But I just think we have to understand what our bills accomplish. And in all honesty, I can't tell you what this bill accomplishes given all the limitations that are identified in the bill from all these federal laws. So that's my biggest hesitation with this bill. But you have other witnesses you want to testify this morning? So I hope you're going to completely educate us on everything we need to know about federal laws in this domain.
Well, thank you, Mr. Chairman. This is, Colin Crossman again. I'm again here in my personal capacity and not representing any entity. To get back to a point that was brought up just a second ago by you, Mr. Chairman, you mentioned how the federal government and the Constitution provide that the federal government has preeminent international affairs power, which is absolutely correct. However, and the reason why things like the Foreign Sovereign Immunities Act and the International Organizations Immunities Act are directly referenced here is because they each carve out a small section where states still have power. And so part of the reason why this bill is as lengthy as it is because it is attempting to go through and collect all of those little pieces of state power that's remaining and assemble them into what we have here. So that to the extent that Wyoming has power in this area, we are going to exercise it to protect our citizens, our entities, and anyone who is here. That's the point of all of that. That's, okay, well, that's the sword component. The shield component with respect to the non-recognition, those two things are different concepts. We are saying that on the non-recognition, unless we are forced by the federal government, it's effectively an anti-commandeering argument. We're not going to help enforce these judgments, which we believe are that violate our principles and our laws and our Constitution, unless the federal government demands that we do so. So, and they have, of course, tools to do that, but they would have to affirmatively force us to. So it's an anti-commandeering argument in that component of the law or the bill. And then it's we are collecting as much remaining sovereign power that the state of Wyoming has and utilizing it on the sword component to protect our citizens. And of course, it only comes to play. I believe Representative Chestik mentioned earlier, you know, or maybe it was yourself, that you know, does this look like we're acting extraterritorially? To some extent, maybe it does look like that, but it's not actually that way. In order for us to act extraterritorially, the other jurisdiction has to act extraterritorially first. They have to say, we are applying this law to you and punishing you, even though you're not in our jurisdiction. We are punishing your speech here in Wyoming. And then only then does Granite say, you can't do that. We are going to punish you for that. So this isn't a license to go hunting for foreign jurisdictions. This is they're attempting to act extraterritorially, and then we are coming back and saying, no, you can't do that.
Representative Chestik.
Thank you, Mr. Chairman, and thank you, Mr. Crossman, for being here again. So help me understand how a foreign government has any power to act extraterritorially in our country. So let's suppose somebody in Wyoming posts a video that some third world country or some Arab country finds offensive, and they want to punish the individual who posted it. How do they have the power to do that? The commandeering problem you're talking about. Where do they get the power? As I mentioned, I'm not aware of any full faith and credit clause for foreign law. So they don't have, their law does not apply in America, and we don't have to obey. How do they get the power to try and punish? Show me how that happens.
Mr. Crossman.
Thank you, Mr. Chairman. I'm going to defer a more technical aspect of the answer to that question to an individual who is on Zoom later, but to get to it in summary right now. Part of the theory is that the internet exists in all jurisdictions simultaneously. So a speech is, if I am here on the street corner and I utter something that a foreign government would find offensive, nobody's going to care. It's fully protected here in Wyoming. I'm here in Wyoming. Nobody outside of Wyoming can hear it. If I do it on the internet, other jurisdictions have taken a position, Europe, the UK, have taken the position that if it's on the internet and our citizens can hear it, we have jurisdiction over it. You are correct, there's no full faith and credit, but once a judgment is issued against them, then there are components of international treaties and international law that allow that judgment to come to the United States. We do have, many years ago, the federal Congress passed the speech law, SPECH law, to specifically protect American citizens solely from defamation. It's basically an anti-SLAPP law, but solely from defamation cases brought in the UK. Because the UK's protections on defamation they pale in comparison to what we have here. So the Speech Act explicitly prevents those judgments for defamation in the UK from being enforced in the United States, but that is the extent that it goes. Granite looks at the Speech Act and says, okay, that's what they did here. Let's do this. We're doing it on a state level, so we have to collect all of these pieces of state power to assemble to do it. But that is the theory one of the theories that we're operating under. In addition, I should point out, and this will come up in the amendment package later, there is a federal push to create a federal Granite Act. It's based loosely on this piece of legislation that we drafted here. And one of the amendments that is being brought specifically is designed to make sure that our bill dovetails with whatever is passed by Congress. So we are attempting to make sure that it is evolving to connect with that.
Further questions? Thank you. Do you have another witness you say on Zoom?
Yeah.
Bring him in, please. What's the last name? Byrne. Good morning, sir. We are really up against the clock. So as briefly as possible, identify yourself and tell us what you'd like us to hear about this bill.
Thank you, Mr. Chairman, members of the committee. My name is Preston Byrne. I am currently, I think it's arguable that I might be one of the more experienced anti-censorship or foreign censorship lawyers on the planet. I've been working this particular problem for 8 years, mostly pro bono or low bono, for a range of American targets against a wide range of foreign censorship regimes, including Brazil, Germany, Russia, Singapore, Australia, New Zealand, England, France, Spain, you name it, I've seen it. When the UK, Australia, and the European Union began bringing their large censorship, internet censorship schemes online at the beginning of 2025, they targeted 4 small American companies, highly controversial, and they were neither able to afford a defense nor able to find counsel willing to provide that defense. Accordingly, I assumed that defense, and with my co-counsel, Ron Coleman, who's one of the only other lawyers who has handled this kind of a problem in the past, we launched a counteroffensive against the United Kingdom's approach, which was the first of those schemes out the gate to silence American speech. That included refusing foreign orders, communicating with Congress and state legislators about this problem and explaining it to them and educating the White House about this problem. And in addition to that, bringing a lawsuit in the District of Columbia against the UK's communications regulator, Ofcom, where the communications regulator, we sued them for a declaratory judgment, a very simple request, asking a U.S. court to confirm the principle that a foreign order, a censorship order, delivered by email was not enforceable in the United States on account of the fact that it wasn't properly served. Ofcom responded to that lawsuit, that's the UK's communications regulator, the Office for Communications, by invoking sovereign immunity. We objected to that invocation of sovereign immunity by arguing that the commercial activity exception to the FSIA applied, and accordingly that the court should hear the case. What's happening here is very, very simple. And what this bill does, as has been explained very capably by Representative Singh and Deputy Secretary Crossman in his personal capacity, is really simple. It gives certainty to Wyoming citizens that when these orders are received, and Wyoming residents and persons hosting speech in and from Wyoming, that when they receive one of these foreign orders, they can be secure that no Wyoming court will enforce it against them. At the moment, those principles are found in various places. You can reason by analogy and find similar cases in similar settings, but there's no rule written down anywhere which specifically identifies that a foreign censorship order isn't going to be enforceable in the United States, and this does that. The second thing it does, part of the shield, is it prohibits cooperation with these foreign agencies when they try to get into the United States. Germany was able to obtain the cooperation of the Biden administration in 2023 in relation to the service of its orders via the U.S.-UK mutual legal, or excuse me, U.S.-Germany mutual legal assistance treaty procedure. We notified the Trump administration about this in April. Those orders have since stopped being served, and Germany is now serving those notices by email, or excuse me, by airmail, which is legally ineffective in the United States. The third thing it does, as the Representative Singh has explained, is it creates a cause of action. That cause of action does not arise in relation to any foreign conduct or foreign law, and it doesn't seek to intrude on a foreign government's sovereign domain. What it says is, much like existing cases that succeed under the Foreign Sovereign Immunities Act now, under the existing exceptions, is that if the conduct occurs in Wyoming, if there's a tort in Wyoming, just like if there were a breach of contract, if, for example, the British government employed an individual in Wyoming and then breached its employment contract with that individual, the British government could be sued in a Wyoming federal court. This says there's a new private cause of action where if you try to silence a Wyoming citizen, you're going to be on level playing field with the United States government, in that the U.S. government can be sued for that conduct, for interfering with someone's constitutional rights, and the individual in question can get all kinds of relief, declaratory, injunctive, etc. So what this does is it tries to carve out a zone of non-interference in the state of Wyoming for speech and conduct that occurs within Wyoming. If a foreign government comes to Wyoming and seeks to influence constitutionally protected activity in Wyoming, then a Wyoming citizen resident or someone who's hosting speech from Wyoming, I think, should have a right to seek redress in a Wyoming court for that. in terms of, the Colin and Daniel have explained that there are numerous savings provisions. I don't have anything really to add to that, but his explanation is how I understand it as well. That's designed to ensure that this bill does not tread on the federal government's sovereign domain and where it's supreme. What I will say is that copies of this bill have been supplied from the moment it was a blog post. Actually, from the moment it was a list of bullet points, it was supplied to the Senate Judiciary Committee. It then became a blog post, which was also supplied to the Senate and the House federally. Then copies of this bill, as it has evolved, have been provided to both committees. And there's been a continuing process where we have engaged mostly one-way communication. They don't tell us a whole lot, but they keep telling us, listen, we want to know every censorship order that we've received has been forwarded to the federal government and everything else. So I think that this bill, the original proposal came from my blog. Colin and Daniel took it and turned it into an amazing bill. If I'm the father of the Granite Act, then they're definitely collectively its mother. And what I would say is that I will add also, just for your information, I've been an English lawyer for 17 years and a US lawyer for 8. So this is very tailored, even though it's lengthy and even though it seems complex, it is very tailored to ensure that these issues that you've discussed about federal supremacy and Wyoming not wanting to intrude on foreign policy of other states or tell the UK what it can and can't do on its own territory, those have been thought out. And the bill is designed to be confined to the borders of Wyoming. And if something comes into Wyoming, that's when this bill really becomes effective, both the shield and the sword. As long as the foreign government in question doesn't cross into Wyoming's territory and start trying to tell a Wyoming citizen or resident or someone who's hosting speech in Wyoming what they can and can't do, then the bill, as I read and understand it, really has nothing to say about foreign policy, about the federal government's powers, about what a foreign state does within its own borders. It's really only when it enters the state that this bill becomes relevant. So that's my testimony, and thank you very much for giving me the opportunity to testify today.
Thank you. Appreciate you joining us. One of the advantages of Zoom testimony that we've brought in post-COVID gives us the opportunity to bring in people with expertise from all over the place. And while we like to have Wyoming people make Wyoming law, there is a place for those experts from outside, and appreciate you joining us today. Questions for Representative Chesty?
Thank you, Mr. Chairman. Thank you, Mr. Byrne, for your testimony here. Very informative, but I'm still struggling to understand where the problem exists with current law. The jurisdiction of various courts is limited to their geographic area. I understand that the internet is all over the place, and if somebody in Wyoming said something online that gets published over in some other country, wouldn't it be up to that other country to prevent its citizens from seeing that?
Yes, yeah. Sorry, if I may.
So through the chairman, Mr. Byrne, please.
Sorry.
All right. So say, Mr. Chairman, and then respond to the question.
Mr. Chairman, apologies, Mr. Chairman. Mr. Chairman, if I may, I represent 4 very small companies. These companies received letters from the United Kingdom demanding the first set of letters that went out were letters demanding that these companies turn over internal records and produce documents under threat of fines, these titanic fines that have been described, but also arrest and imprisonment. So when I made contact with these small internet entrepreneurs, they were terrified of these letters. And when I then went to go render advice to them and said, okay, listen, what's our response here? The answer was I typed up a 10-page memo and said, here are a bunch of different cases where in various different settings, where by analogy, we can reason that you are not liable and that you will not be able to be arrested for this conduct and extradited. But there's no rule anywhere on our statute books, anywhere in the United States, which makes it clear that when one of these threats enters the United States, it's not going to be enforceable, and you can raise this shield as an affirmative defense to that conduct. So what the UK has done to several American companies and also to the executives of larger American companies like Facebook and Reddit and X, although those efforts have been have not been as blunt and not as direct, is they're threatening American citizens with arrest for failure to comply with this regime. I think yes, we can turn around and we can say, all right, we're we can reason by analogy, dare the UK to try to enforce it, and then have them, come to an American court, which of course they'll never do because they know they would lose. But ultimately what they're doing is they're terrorizing American citizens with these threats. And so the bill is designed to prevent those threats from being transmitted into the United States because it recognizes that the threat itself has a chilling effect on American speech. So I think that what the bill does is it prevents the outbound transmission of those threats. It prevents American citizens from fearing those threats. Because I think, as you know, there's a long history we have in this country of free speech and erecting procedural and legal guardrails for the government. And if our own government, if the federal government threatens someone with arrest for exercising a constitutionally protected right, that's a crime in the United States. That's a felony it's deprivation of rights under color of law. So I think what this does is it makes it clear. It doesn't say that it's a criminal offense for a foreign government to do this, but it creates a deterrent because at the moment there's no effective deterrent to a foreign government doing this. And in addition to that, when an American is on the receiving end of one of these threats, it's really hard to convince them that the threat can't be carried out and that they won't be extradited to the United Kingdom. We've also seen Sir Mark Rowley, who's the head of the Metropolitan Police in 2024 during the riots over there. American citizens were commenting about those events and the political ramifications of that. And he went onto national television in the UK and he said, "We will seek to have you unmasked, have you identified, and then have you arrested and extradited if you speak on these matters." And it violates our rules and our laws from the United States. So I think the answer to that is American citizens currently and Wyoming citizens currently lack certainty that these foreign orders are unenforceable here in the United States. I think what the Granite Act would do is provide them with that certainty, even without the private right of action, even before we consider that. But simply just having a rule which states that your protected speech is never going to be punished by a foreign state. We will never let that through, is something which would be very valuable and would ease American citizens' anxiety over this question.
Thank you, Mr. Byrne. Follow up, Representative Shustak, we're at 20 minutes.
I understand. And thank you again, Mr. Byrne, for your testimony. So I still have a lot of problems with a lot of concerns about the bill. So suppose the bill is enacted and a U.S. citizen, a Wyoming citizen, has received one of these threats from a foreign government, and we enforce the bill as written. There's a lawsuit here in Wyoming that creates a $1 million judgment against the company that was trying to suppress the speech. How does and he gets the verdict, gets the judgment. How does he enforce that in the foreign country?
Mr. Byrne.
Mr. Chairman, I think, so walking through the complete procedure with that, the foreign censorship order would enter the United States. If I were doing it, we would respond with a letter to the other side saying, please cease and desist, because this is not enforceable here. If the conduct persisted, a lawsuit would issue. That would need to be filed in federal court. The other side would likely then file a motion to dismiss so it wouldn't proceed to judgment right away unless the other side chose to default and not answer the lawsuit. If we assume that it were contested, the other side would file a motion to dismiss under 1608, under the Foreign Sovereign Immunities Act. It would then be up to the American citizen in question to rebut that by asserting that an exception applied. The exception that we asserted was applicable in our lawsuit against the United Kingdom was the commercial activity exception. That's currently pending before the district court in the District of Columbia, so we don't know what the outcome of that is. We made our arguments, the other side made their arguments. If Congress were to create a carve-out, presumably that would be a further amendment or an amendment to the FSIA, then that would be something that exists, but we're going to assume for sake of argument that isn't the case. Then let's say, just for sake of argument, that it does get through. It goes to a merits trial. It's decided in favor of the Wyoming plaintiff, and then you have to enforce the judgment. Presumably, the judgment would not be enforceable in an English court. So you could try to get it enforced in an English court, but I think for public policy reasons, an English court, just for sake of argument, we're using England because they've been the most aggressive in trying to project their power into the United States. However, these foreign countries do have assets within the United States. They also need those assets here in order to support foreign currency exchange operations, dollar clearing, and other things. We've seen previous examples where countries like Argentina have had assets attached to satisfy American judgments in the United States. This is something which has happened before. And so that is where the deterrent value of this comes from, is that essentially foreign countries do need to touch the United States. They do have assets, sovereign assets in the United States. And if the federal Congress deemed it, so either if the country engaged in a course of conduct which waived its sovereign immunity through one of the existing waivers, or we had a new waiver of sovereign immunity, as we've asked Congress to enact, and they've said they're considering enacting, which would provide for enforceability of that judgment, there would be assets available to satisfy that judgment in the United States. Without further congressional action, there's certainly the options are limited. It's more of an uphill climb for sure. Being completely transparent about the challenges that we had, but there are arguments which can be made, and it's up to the other side to raise sovereign immunity as an issue, right? It's up to them to appear in an American court, make the arguments. And when a foreign sovereign, being completely frank, when a foreign sovereign asserts, as the UK Ofcom did in writing, both in their pleadings and in communications to my clients, that the First Amendment does not apply, does not restrain their conduct on American soil, and that they have authority on our soil to control our speech and conduct, that's something which we think it's important to get them on the record as asserting in an American court, if that's something that, as we have made them do in this case. And it's something where we should make them show up and answer to our American courts for that. And so if there are immunities that apply to their conduct, it's up to them to raise it. That's I think does that answer your question, I hope?
Thank you, Mr. Byrne. Further questions? Thank you. Question? No? Representative Bratton.
Thank you, Mr. Chairman. Why is this not federal? It seems like this would be better at the federal level.
Mr. Byrne. Again, we're up the clock.
Yep, I'll be very brief. It's a state and federal question. Wyoming has it within its power to protect its own citizens from this kind of conduct within its sovereign authority, under the powers it has under the 10th Amendment. So why is this not federal? Because the federal government hasn't moved yet. I think that there's a lot of value which can be added to the state of Wyoming by doing this to protect its own citizens. My client 4chan which has been targeted by the UK, has approximately 3,000 users in Wyoming. The United Kingdom asserted its power over 4chan. If 4chan were to fold to that, the request that they made, those users would not be able to speak freely. Those users would be de-anonymized. At the moment, 4chan's an anonymous website. Anonymity is protected. Anonymous speech is protected under the First Amendment. So it's a very real problem at the state level in Wyoming for 3,000 people, I think is the answer to that question. So why is it not federal? Because it's a problem now for Wyoming. It's a problem in every state in the union. And it's just that the recency of the national awareness of this problem, as I mentioned at the beginning of my testimony, I've been doing this for 8 years, but nobody really noticed or cared until this year. And really, nobody really noticed or cared until about 9 months ago. So this is a very long-standing old problem. And I think we can begin to implement a solution if certain states move forward with their own shield bills that protect their own citizens. And I think the federal government is looking to the states in this case to see if the states think this is a good idea, if they think it's something that they want to do. And then once they see the outcome of the state process, I suspect a federal process, as Undersecretary for Public Diplomacy Sarah Rogers has said, federal shield bills are in the works. Senator Eric Schmidt has vowed to introduce a shield bill. His office has been supplied with a copy of this bill, as well as every censorship order that's been sent into the United States. The House Judiciary Committee has said they're considering a shield bill similar to this one. They've been provided with all of these notices. But let's just work out on some timelines here. Let's assume Wyoming passes this, for sake of argument, that Wyoming passes this bill and that it's signed by the governor on March 15th. I can guarantee you that at least 4 out of the 5, and possibly 5 out of the 5 targets of the UK Online Safety Act would either reincorporate in Wyoming immediately, or would start hosting in Wyoming, a CDN edge server immediately, and would therefore protect the rights of those 3,000 Wyoming. In 4chan's case, the 3,000 Wyoming citizens who are its users would be immediately protected. I guess it's a question for you to decide. But from my point of view, it's hard. It's hard when you look at the problem in the abstract, but when you actually look at the data and you see, okay, there are 3,000 people in Wyoming. It's a lot of people who would be directly affected by the UK's censorship order in the 4chan case. The question is, should the legislature act then, or should the legislature wait for the federal government to act? That's a question obviously I can't decide. I, of course, have my own personal opinions about it, but I think it's an emergency problem, which affects everybody today. And just, it's legally very strange and legally very obscure, but it's very real, and it's happening as we speak.
Thank you, Mr. Byrne. Others in the room wishing to testify on House Bill 70? We're down to 10 minutes.
I won't take 10 minutes, I promise. Thank you, Mr. Chairman. James Halverson with Americans for Prosperity right here in Wyoming. We just think this is a very good bill. We think that this is obviously asserting our sovereignty, and I don't think it should be lost on us in this room that what this could be doing for business in the Cowboy State. We want to encourage people to live and work here. This is a great thing that will signal to the business community that we have their backs, and we think this is a good law. So with that, I'll stand for questions.
Thank you so much. Any questions? Appreciate it. Anyone else wishing to testify? House Bill 70. State your name for the record and tell us briefly what you'd like us to hear.
I'll be brief, Mr. Chairman. My name is Dale Steenberg, and I'm President, CEO of the Greater Cheyenne Chamber of Commerce, and I also manage the Wyoming Chamber of Commerce. So I think the one thing we haven't talked about is that one area that Wyoming is really trying to move forward in is moving these tech businesses to the state. This is an enticement to them. This EU thing is really complicated, as you guys have noticed, but we can be a leader in this area. So, Mr. Chairman, I just leave it short and say business supports this, and we do have a concern about making sure that if the federal government passes a law, that we don't have a patchwork of laws around the country. I think they've got an amendment to try to tie that up. But this could be really good for folks that want to move to Wyoming and do tech businesses, and it's something we have been after.
Thank you. Appreciate that. Anyone else wishing to testify on House Bill 70? Representative Lane, bring us home.
Mr. Chairman, I'm sorry. So we do have just some amendments that have been distributed to the committee.
We have 10 minutes.
Yes, and so for a brief
Are these your
explanation of
amendments?
that. Yes.
Okay, great.
Preferably we do it as
You're
one large.
proposing amendments to your own bill.
Yes.
All right. We'll get to those. We're going to finish up public comment if you want to bring us home on public comment.
No, Mr. Chairman.
Okay. No further public comment. We're going to close public comment. Committee, what's your pleasure? Moved by Representative Lean, second by Representative Webb. All right. Amendments on the bill. Representative Singh. It's always in order. Representative Chester.
Thank you, Mr. Chairman. Before we spend a lot of time on amendments, I know we have 5 amendments and 10 minutes to do them. The amendments look kind of complicated, but it just seems to me that this bill is not quite ready. It's very complicated. We've heard a lot of testimony about Congress working on things and other states working on things. This is a new project that's never been tried anywhere else yet. It's involves complicated questions of federal, international law. And I really think it's so complicated. We don't have time in during the interim generally to deal with all the complexities of this bill. I would therefore move to table the bill indefinitely. Well, table it and then recommend it for an interim topic and take it up over the interim when we have more time to study it and know what we're doing.
Motion to table is in order. Call the roll on motion to table.
Representative Brady. Representative Breton.
Aye.
Representative Chestik.
Aye.
Representative Filer.
Excused.
Representative Kelly.
Excused.
Representative Lean.
No.
Representative Singh.
No.
Representative Webb.
No.
Chairman Washut.
Aye.
4 ayes, 3 noes, 2 excused.
With that, the bill, House Bill 70 is tabled. I too will support the idea of this being an interim topic. I think it's super important, but I just don't think we have time in a budget session to work through all the intricacies of this. And so with that, we'll conclude House Bill 70. We didn't get to House Bill 91 today. We will look at the remaining bills and put out notice for what we'll do on Wednesday and Friday. Those are the last 2 days we have for committee bills. We stand until Wednesday.
Really got a lot of work.